and in this video we will take a look at criminal law. Remember, we are not going to understand the intricacies of the law of the land. We are not going to understand the exact definitions as laid down in the IPC or the CRPC or any such thing. Rather, we are just going to understand some basic concepts and see how to go about solving questions of legal aptitude as presented in various law entrance examinations. So what exactly is criminal law all about? Well, the law of the land deals with different subjects, and we could divide law into two broad categories. One are those which are known as civil laws, and the second set are those which are known as criminal laws. While civil laws would normally deal with matters in which it is only an individual's rights which are being affected, under criminal law we would generally deal with those things which affect the society at large. So normally when I ask students to name some crimes which they already would know about, the things which would come to mind immediately are things like theft, robbery, arson, murder, and so on. Now, if an individual gets murdered, then how does the society at large get affected? Well, if one person gets murdered, then the other people are also worried about their safety. If one person could not be protected, then the others do have some reason to worry that even they might fall victim to the same murderer. So, criminal law generally deals with those things which affect the society at large. But we need not worry too much about this distinction. The basic purpose of criminal law, or rather any law, is manifold. One, obviously it is to protect the general public from harm. So because there is a set of rules, there is a set of laws laid down, people would follow them and desist from doing anything wrong or harmful to others. But in case someone does something wrong, let us say a person is not supposed to kill others, but he does take somebody's life, then according to the law of the land, that person who has done wrong should be punished. Laws also serve as a deterrent. Now let us say I am tempted to kill somebody, but I have already seen people who kill others being caught and punished severely by the law. So this knowledge that should I do a similar wrong activity, even I will not be spared, it serves as a deterrent and it prevents me, or at least gives me a second thought before I go ahead and commit that crime. So these are some of the basic purposes of any law. Now, let us take a look at different examples and try to understand how to go about solving examples. The way I am going to do it is, first I am going to give you a situation, and then we will talk a little bit about that situation, and then take a look at a principle which can be given in such an example. For any crime, however, remember there are two things which you have to take into consideration. One is the wrongful act itself, what is known as the actus reus. A lot of Latin is used in law. So actus reus, the act, and more importantly, the mental element or the intention behind that act, what in Latin is commonly known as mens rea, state of mind. So to constitute a crime, there are two things which need to be considered. One is the wrongful act itself, and second, the intention or the state of mind which went behind that act. So let's take an example. Let us say a Captain Sodhi of the Indian Army fires on a mob by the order of Colonel Balbir, his superior officer. Now, although he does everything in conformity with the commands of the law, a stray bullet hits Ramu, who happens to be in that mob, and this Ramu sustains a major injury. Now, Ramu was not an active part of the mob, he was simply an innocent bystander. But because Captain Sodhi fired, this person got injured. The question here is, can Ramu actually sue Captain Sodhi for anything? Or to put it in another way, can Captain Sodhi be held liable for the injuries sustained by this innocent person, Ramu? Let us take a look at another example. Let us say there is a person called Amar who is an officer of the Court of Justice, a policeman. Now, this officer is ordered by the court to arrest somebody called Yatin. Now, after making all due inquiries, Amar is led to believe that a person who is in reality someone called Zahir is the person he is supposed to arrest. So he thinks that this person is Yatin, but in reality it is Zahir. So Amar, believing Zahir to be Yatin, arrests him. Now, in due course of time, if Amar's mistake is brought to his attention and Zahir is let go, the question is, can Zahir have a suit of action which he can bring against Amar? Or can Amar be held liable for arresting Zahir when in reality he was innocent? Now let us take a look at the principle or rather the exceptions which law has. See, the general rule is if you have committed something which is not to be done and which has harmed the right of the other, then you are liable. But there are certain exceptions to this rule. So the general exception given would be the act done by a person who is bound or by mistake of fact believes himself to be bound by law. So in such a case, the act of that person is not liable for punishment. So take a look at the first example. The one where the captain, under the order of the colonel, fired the bomb. Right? The captain did not do anything wrong. It was not his intention to hurt anyone. He was simply following a legal order given by his superior officer. It is the captain's duty to follow the commands of the officer. The commanding officer has given him an order which is in line with the law. So although Ramu was innocent, although he was hurt by the bullet which the captain fired, the captain did not have any guilty intention. He was simply performing his duty. He was bound by the law, and hence he cannot be held liable for his act. In the second case, although Amar did commit a mistake, Amar did arrest the wrong person. However, Amar thought that he was bound by law. Right? If you read the facts of the case carefully, it is said that after due inquiry, which means Amar did do his duty. By some fate, he happened to arrest the wrong person. But in his mind, he was arresting the person who was supposed to be arrested. That is, Amar thought that he was bound by the law to arrest this man. And hence, again, he cannot be held liable. So in both the cases, because of this particular general exception, we would say that neither the captain nor the officer of the Court of Justice can be held guilty. Now, similarly, there are a lot of other exceptions where the act of the person, although might cause a harm to other, the person himself or herself cannot be held guilty because of certain exceptions. What are these exceptions? One, the act of a judge when acting judicially. So, when a judge in a court case pronounces a verdict, you cannot accuse the judge of harming the other person. Although he does so intentionally, but he is doing it because it is his duty to do so. Like, nobody can call a judge who orders a person to be hanged till death to be ordering a contract hit on somebody. No. That would be extremely wrong. So, when a judge is punishing a person in his role as a judge, he cannot be held liable. So, one might argue, what if I am a judge? At night I am sleeping in my house and some person happens to come to my house to commit a robbery. I wake up, catch hold of this person. I am a judge, so I immediately bind his hands and legs and keep him captive in my storeroom for 7 days. So I cannot be punished, right? No. In my house, I am not a judge. In my house, I am a private citizen. I cannot take the law into my own hands with the claim that I am a judge and I can do so. The proper procedure would be to temporarily restrain the person till the time I can call the police and then hand over this person to the police. So it's only when I'm acting as a judge that I can pronounce a verdict and not be held liable for it. Similarly, any act which is done pursuant to the judgment of the order of a court cannot hold a person liable. So the judge orders a person to be sentenced to death. The executioner or the hangman carries out this sentence. So one cannot claim that the executioner or the hangman is guilty of killing a person. Legally speaking, he was simply doing the act in pursuant to the judgment given by the court, to the order given by the court. So this is the second exception. As we have already seen, the act which is done by a person who is either justified or by mistake of fact believes himself to be justified by the law. The two examples which we saw, the captain firing on the mob and injuring a bystander, or in a case of mistaken identity, the police arresting the wrong person. In both these cases, the first one, the person is justified by the law. In the second one, because of a mistake of fact, the person thinks that he is justified by the law. And finally, if there is an accident in doing a lawful act, then it is merely an accident. One cannot say that a person is liable for that accident of his. Of course, the person should have taken due care. He must not be negligent in his act.